Let's fill out the Colorado General Power of Attorney together, the document that lets someone you trust handle your money and property. Start with you, the principal. Type your full legal name and where you live. Use your full legal name exactly as it appears on your ID, so there's no doubt who signed. Now name your agent, the person you're giving authority to. Here, Ben Carter, with their address. And name an alternate. Here, Carlos Diaz, in case your first choice can't serve, so your document doesn't stall if something happens. Now the powers. The form lists subjects, A through N. To give your agent authority over everything, initial the line in front of N. To grant only some, initial just those specific lines instead. Then choose when it takes effect. Here, effective immediately. One important thing. Depending on your state, a general power of attorney may stop working if you become incapacitated. If you want it to keep working no matter what, ask about a durable power of attorney instead. Finally, print your name and date it. Sign it the way your state requires. We'll cover those exact rules in the recap. Then give a copy to your agent and to anyone they'll deal with, like your bank. First, the document must be signed by the principal. That's the person granting the authority. Now, if the principal cannot sign personally, another individual may sign the principal's name on the power of attorney, but only in the principal's conscious presence, and only when directed by the principal to do so. Next, here's a helpful tip about that signature. If the principal acknowledges the signature before a notary public or another individual authorized by law to take acknowledgments, the signature is presumed to be genuine. That can save a lot of headaches later. Once you have a properly executed original, good news, a photocopy or an electronically transmitted copy of that original power of attorney has the same effect as the original. So sharing it with banks or other institutions becomes much more convenient. Now, when does it take effect? By default, a power of attorney is effective as soon as it is executed, unless the principal includes language saying it becomes effective at a future date or upon the occurrence of a future event or contingency. So if you want it to kick in right away, you don't need to add anything extra. Finally, which state's law governs the document? That's determined by the law of the jurisdiction indicated in the power of attorney itself. And if no jurisdiction is indicated, then by the law of the jurisdiction where the power of attorney was executed. Remember, this is general information, not legal or tax advice.